If you're watching this video, that means you've been summoned for jury service. As a juror, you're joining the millions of Americans who participate in the judicial process each year by listening to evidence presented in a civil or criminal trial and deciding the verdict. But why is jury service so important? Well, because it ensures the law is applied fairly and justly. The right to a trial by jury is enshrined in the Sixth Amendment to the U.S. and Florida Constitutions. The jury is a fundamental part of our justice system, upholding constitutional rights to a trial with impartial peers deciding the fate of the accused. When you serve on a jury, you're not only fulfilling your civic duty, but you're also actively maintaining the public trust in the justice system by demonstrating that it's an impartial process. Thank you for appearing today as a potential juror. I hope if you are selected, you will find serving as a juror meaningful and rewarding. While jury duty may be inconvenient in some respects, you should be proud of your contribution to the cause of justice. Leading up to and during the trial, there are several key roles to be aware of. The judge presides over the proceeding to ensure that order is maintained and is responsible for the conduct of the trial according to the law. The judge is also responsible for sentencing convicted criminal defendants. In jury trials, the judge instructs the jury on the law as it applies to each case. In most counties, the clerk of court is responsible for facilitating the jury process and is involved in many functions, such as the initial random selection of jurors called, summoning jurors, managing exemptions, and compensating jurors. Clerks are also typically responsible for documents, court records, and physical evidence entered into the trial, and swearing in members of the jury and witnesses. The bailiff is a sheriff's deputy assigned to the courtroom and will be present whenever the court is in session. The bailiff is responsible for maintaining order of the court, following instructions from the judge, and escorting and looking after the jury. The court reporter records court proceedings such as hearings, trials, and depositions, and, when necessary, providing a timely and accurate transcription of the proceeding. The defendant and the plaintiff are the active parties directly involved in the case. The person who brings an action against another is the plaintiff. The person against whom the action is brought is the defendant. Attorneys are responsible for representing and defending the clients in court. Typically, both the defendant and the plaintiff are represented by attorneys. And of course, the jury. Jurors are responsible for reaching the verdict in trials and are duty-bound to do so fairly and impartially. The cases that come before a trial jury are divided into two general classes, civil and criminal. A civil trial is among parties who have a dispute and need the court system to resolve it. In a civil trial, the plaintiff is the party who has filed a suit, and the defendant is the party being sued. They're in court to settle the disagreement between them. A criminal trial deals with charges when a crime has been committed. In criminal trials, the attorney representing the state of Florida, referred to as the state attorney, is bringing an action against the defendant or the party accused of violating a law. The purpose of this type of trial is to determine whether or not a state law has been violated by the defendant. Before serving, it may be helpful to understand what jurors may expect from this experience. First, let me assure you that everyone involved in the process is aware of your time and will work to ensure your service is as brief as possible. The Florida legislature states that our courts use the 1 day or length of one trial system. If you are selected for a jury on the day you report, you can expect to serve until that trial is completed. Many cases settle on the day of the trial. However, a complex trial can last for several weeks. If you report for jury duty and are not selected, your service will be considered complete, and you will be recognized as having fulfilled your obligation to serve as a juror for 1 calendar year. While jury service is considered by many to be a civic duty, the court system recognizes that it may interfere with work or other personal responsibilities. Jurors are compensated in accordance with Florida law, and jury payment does not affect unemployment benefits. Jurors who are not employed or are retired or do not receive regular wages from their employer receive $15 per day for the first 3 days of jury service. Jurors who are employed or receive regular wages are not entitled to be paid for the first 3 days of service. Jurors who serve more than 3 days will thereafter be paid $30 per day of service. Your first encounter with the courtroom will be during the jury selection process, also called voir dire, a French term meaning to speak the truth. During this process, the judge may reveal details of the case, and the attorneys will question the jurors to see if there is any reason why a juror may not be impartial. For instance, jurors may be questioned about possible relationships they may have with the parties involved, or if they have any prior knowledge related to the case. It is crucial for prospective jurors to give complete and honest answers to ensure a fair and balanced jury is selected.
Do any of you know the defendant in this case? If so, please raise your hand. The record will show one affirmative response. Ms. Johnson, can you tell us the nature of your relationship with the defendant?
Each side has a certain number of peremptory challenges, meaning an attorney can request excusal of a particular juror without having to give a reason. Each side also has an unlimited number of challenges for cause, where the attorney must explain the reason for requesting an excusal of a juror. The judge rules if the cause is appropriate and decides if the juror is excused. Once the jury is selected, the trial is ready to begin. Attorneys representing the defendant and the plaintiff usually make an opening statement outlining their case.
Members of the jury, the state will be calling several witnesses in this trial, and we will also be presenting multiple pieces of physical evidence that supports our case. The defense will argue that this evidence is circumstantial, but we will provide a direct line of evidence linking the defendant to the charges at hand.
Opening statements are not evidence, but instead an overview of the case and evidence that will be presented. Evidence includes statements, exhibits, and objects used to establish facts of the case. It may include physical exhibits, such as a document or weapon, which are introduced and explained by the party offering them. Most evidence will be in the form of oral testimony from witnesses. Both sides are allowed to call witnesses and to question the opposition's witnesses. It is the juror's responsibility to sort out the facts from all evidence presented. That means assessing the credibility and believability of each witness. When hearing witness testimony, jurors should listen carefully, take notes if permissible, and observe manners and expressions. Throughout the trial, it is crucial for jurors to maintain confidentiality about everything that occurs in the courtroom. Even talking with your spouse or partner about the case can be an act of contempt, punishable by fine or imprisonment. A simple rule to follow is that you should avoid even the appearance of an improper discussion. If you believe someone has purposefully tried to talk to you regarding the case, it is your responsibility to notify the judge immediately. While you are in the courtroom, elevators, lunchroom, or anywhere else, please do not talk with lawyers, their clients, or anyone interested in the trial. It is also considered a violation of jury service for jurors to conduct their own investigation of the case. Jurors should not visit the scene of an accident or alleged crime or make any attempt to question witnesses. That is the responsibility of the attorneys when presenting their cases to you. Sometimes during a trial, attorneys will be allowed to approach the judge and hold private conversations. These conversations, or conferences, are not for the jury to hear, because they concern technical points of the law and courtroom procedure on which the judge alone must decide. The judge may excuse the jury or recess the court to resolve the matter. Conferences are necessary to ensure a fair trial for all parties and are not used to intentionally delay court procedure. After all evidence from both sides is presented, attorneys will summarize their respective cases in a closing argument. The closing arguments are not evidence, but you should listen carefully. After closing arguments, the judge will instruct jurors on the law that applies to the case. Jurors will apply the law to the facts, so attention to the instructions is critical. The judge in any case is the ultimate authority on the law, and jurors must accept the law exactly as it is delivered. After the judge gives instructions, the bailiff escorts the jury to the jury room for deliberation. Your first order of business is to elect a jury foreperson. The foreperson will preside over the deliberations to maintain an orderly flow of discussion and ensure each juror is given an opportunity for personal expression. During deliberations, there may be differences of opinion and possible arguments. If so, listen to opinions. Form your own opinions, state them, and keep your mind open to the opinions of others. Then, by applying the law the judge gives you to the facts presented, vote the way your intellect and conscience tell you. The foreperson oversees the process of juror voting. When a verdict is reached, the foreperson will inform the bailiff that a decision has been made. Do not tell the bailiff or anyone else what decision has been reached. Court is then reconvened, and the foreperson delivers the verdict to the court on behalf of the entire jury.
Madam Foreperson, have you reached a verdict?
We have, Your Honor.
It's the juror's responsibility to protect the rights, privileges, and liberties of each party when handing down the verdict of the court. A fair, impartial, and just verdict depends upon the combined efforts of the jury as fact finders, the judge as presiding officer and the authority of the law, with the lawyers as examiners and advocates. Jurors are obligated to perform this service honestly and conscientiously, and should do so without fear or favor. Once sworn in, there are rules of conduct that jurors should observe. Do not discuss the case with anyone. Avoid social media during the trial to prevent accidentally reading outside opinions or details about the case, which may persuade your decision as a juror. Avoid any media coverage related to the case you are serving on. Arrive early for court sessions. Maintain your composure when listening to testimony. Write down any questions you may have for a witness in the event you are allowed to ask questions. The right to a jury trial under the U.S. and Florida Constitution encourages fairness and justice in legal proceedings. Although some may feel intimidated or inconvenienced, jury service can be a valuable and rewarding public service. It is an essential function of the courts that allows citizens to take part in the justice system. From the judges who preside over the trials to the clerks of court who maintain information related to cases, our goal is to ensure that jury service is efficient, fair, and meaningful for everyone involved in the process.